Jefferson County Court, Law number 2 is back in session. Court is in session with its arraignment docket. Next case is cause number 25-CCCR 0376. The case is styled the state of Texas versus Kafita Jones. Kafita Jones was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's barely called the name of Kafita Jones at the courthouse door. Kafita Jones did not answer. A reasonable time has passed to give Ms. Jones an opportunity to appear in court. She has not appeared in court. The time now is 1:31 p.m. on today's date, June 3rd of 2025. Ms. Bailiff, would you please call the name of Kafita Jones at the courthouse door? Kafita Jones.
Kafita Jones. Kafita Jones. No response, Your Honor.
Okay, Kafita Jones' name was just called again at the courthouse door. Kafita Jones did not answer. Reasonable time has passed to give Ms. Jones an opportunity to appear in court. Ms. Jones' bondsman did call the court this morning indicating that Ms. Jones may be or is in the hospital and that they were going to give the court proof that she is in the hospital. And so until we get the proof, state, what is your motion?
They would move for a bond forfeiture, Your Honor.
Okay, that motion will be granted. Kafita bond will be forfeited. Warrant should be issued for arrest. And if we get the verification, then state you will be
We'll
withdrawing.
make a motion to withdraw
Okay.
verification, Your Honor.
All right, thank you. Next case is cause number 25-CCCR 0820. Case is style of state of Texas versus Leonardo Mendoza. Leonardo Mendoza was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. Leonardo Mendoza's name was called at the courthouse door by the court's bailiff. Leonardo Mendoza did not answer. He has not appeared in court since the court has been in session. At the time now is 1:33 p.m. on today's date of June 3rd, 2025. Ms. Mosby, Ms. Bailiff, would you please call the name of Leonardo Mendoza at the courthouse door? Yes, Leonardo Mendoza.
Leonardo Mendoza. No response, Your Honor.
Okay, Leonardo Mendoza name was just called again at the courthouse door. Leonardo Mendoza did not answer. A reasonable time has passed to give Mr. Mendoza an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
State moves for bond forfeiture, Your
That
Honor.
motion will be granted. Leonardo Mendoza's bond will be forfeited and warrant shall be issued for his arrest in cause number 25-CCCR 0820.
Thank you, Your Honor.
You're welcome. And this will conclude the calling. Another one? Oh, okay, sure is. Let me get the Miss Stolzby. Court is back in session on the arraignment docket. Next case is cause number 25-CCCR 0850. Case is style of state of Texas versus Jaden Young. Jaden Young was scheduled to be in court this morning at 9 a.m. for the arraignment docket. At about 9 a.m., the court's bailiff called the name of Jaden Young at the courthouse door. Jaden Young did not answer. Jaden Young has not appeared since the court has been in session. The time now is 1:35 p.m. on today's date of June 3rd, 2025. Ms. Bailiff, would you please call the name of Jaden Young at the courthouse door?
Yes. Jaden Young. Jaden Young. No response, Your Honor.
Jaden Young's name was just called again at the courthouse door. Jaden Young did not answer. A reasonable time has passed to give Mr. Young an opportunity to appear in court. State.
That moves for bond forfeiture, Your Honor.
Okay, that motion will be granted. Jaden Young bond will be forfeited. Marshal Bishop Boyce, arresting clause number 25 CCCR 0850. Okay, cool. Court will be in recess until we pick the jury in a few minutes. Okay, you ready?
Mhm.
Jefferson County Court Order number 2 is in session in 2 cases, cause numbers 23 CCCR 0642 and cause number 24 CCCR 2011. Case is style of state of Texas versus Alan Colary Valdez.
Right.
That's right. Okay. And let the record reflect that Mr. Valdez is present in court with his attorney. And let the record also reflect that Mr. Glenn Crocker is his attorney. State is present with Assistant Criminal District Attorney Andrew Hubel. Now, today the case is set, these cases are set for trial. And I have before me a written motion that was filed by the state, notice to consolidate and pursuant to Article or Section 3.02 of the Texas Penal Code, when a single criminal action is based on more than one charging instrument within the jurisdiction of the trial court, the state shall file a written notice of action not less than 30 days prior to trial, and that's Article 3.02B. And this motion is filed less than 30 days prior to trial. And Mr. Crocker, do you have any objections to the state filing this motion?
We do not, Your Honor, and specifically, we would waive, if it is waivable, section 302 subsection B's 30-day advance notice requirement.
Okay, and this court will acknowledge that Article 1.14 of the Texas Code of Criminal Procedure states that a defendant in a criminal prosecution for any offense may waive any rights secured by law, except that a defendant in a capital felony case may waive the trial by jury only in the matter permitted by Article 1.13B of this code. And so at this time, these cases, the court is going to grant them motion to consolidate. You know, I might need an order. Could you handwrite me off? Yeah. And then so the court is going to grant this motion to consolidate both of these cases. There are no objections by the state, and just for the record, the defense is also joining in on this motion as well. Is that correct?
That's correct, Your Honor.
Okay. All right. So these cases will be consolidated. That's the order of the court. I'm going to need Trina to file this motion in order.
Okay.
Okay. Let's just say notice. It says state's notice of consolidation is granted, denied in like a circle. And you can put what else usually happen like where I sign on this day. Judge Terrence L. Holmes, kind of got number 2. They filed a motion to consolidate. We're gonna need this here. E-file.
It doesn't have to have a proposal to read it.
The order. The order, he's doing the order now.
Yeah, you have the e-file. Then we isn't a train.
Okay.
I'll watch it.
So so they're gonna print out the order.
The proposal.
So you need him to e-file it? Okay. Okay. So you're gonna e-file it, and then what we're gonna do, I mean, I'm gonna sign it.
And I'll watch it.
Plus, I already got it, I pronounced it on the record anyway.
Can this be handled after jury selection, or does it need to be handled right now?
You can,
Okay.
anybody in your office, somebody in your office?
Scan it in and they can follow it real quick. Just take it up there and see if they can scan it in.
And Ms. Mosley, just let the panel know that we was taking care of a matter outside of their presence.
Okay.
Yeah, so we had to. So they're gonna consolidate these cases and consolidate it. Put them together. They filed on two different now. The state could have filed one information and put both cases in the information. But they chose to file an information on each one of the cases, so they're two separate cases. So in order to get them together, you have to consolidate. You have to file a motion to consolidate. I don't think so. We're just trying them at the same time.
I think so they're still two separate.
Yeah, they're still two separate. We're just trying them at the same time.
Gotcha.
Juror 17, Morales,
Yeah,
he says he doesn't speak English or understand English well.
well, okay, we have some questions to ask that'll come up at that time, okay?
He may not understand.
Well, we'll let us know, somebody.
I'll tell him you went to the restroom. Yeah,
Good. Now, what we saying?
he's going to the restroom.
Oh, yeah. Is both of those doors open?
No, not, I was getting ready to open it until I seen you walked
No,
out.
you can open it.
Okay.
Yeah. Yeah, I got a case. I got a case on point, so. With our situation. Better be safe than to be sorry. Yeah. 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 What I'll probably do is I think Mr. Gidger is number 2 on, okay. Okay, ladies and gentlemen, we have a number 1 case, and the reason why you here, if the number 1 case doesn't go, then the number 2 case will go. If the number 2 case, then we go down the line. Okay, I think Mr. Gidry case is number 2. And you, Mr. Gidry, in the white shirt, is that correct? Okay. So if this one doesn't, and once we start picking a jury, then you all can exit the courtroom. Notice of your reset dates will be sent to your attorneys and your bondsman. Okay? And so you'll stay in contact with them. What you can do is probably start doing those now. You did?
And we can get copies and we'll send it to the attorney.
You're gonna send it to the attorneys? Okay. So once we start, huh?
Or just
We could give them to them, yeah. Well, she already have them. So, but if the case doesn't go, you're gonna sit here, the case doesn't go, we'll go to the next case. Okay?
let's
Yeah.
just like we normally do.
Yeah, but what we'll do, once we start picking a jury, we're gonna have y'all to exit the courtroom and the bailiff is gonna have the resets in her hand. and she'll give you your reset. Okay? Everybody understand? Okay, so you don't have to sit through the whole voir dire. Okay. Voir dire is what they call when we pick a jury. They call it voir dire. I'm thinking as soon as I start talking, soon as we get them in, and we're gonna start asking questions and stuff like that to them, we'll have the, make sure you give that to the bailiff. Where, when she comes in, we need to let her know, so she'll be outside to hand you your resets. Now, if something goes wrong, or if the person decide, hey, or if the state say we're gonna dismiss the case, or if the defense say we're gonna take a deal or something, then the next case we'll start on the next case. Okay, Carrillo, please go all the way down to that first chair. And Mr. Meyer, you're gonna sit next to Ms. Carrillo. Mr. Rhodes? Hey, you're gonna sit next to Mr. Myers. Mary Johnson? You're gonna sit next to Mr. Rhodes? And then we have a seat that's gonna be between Ms. Johnson and Ms. Charlton. Ms. Charlton? You're gonna go on that first row, there's a seat between you and Ms. Johnson. Mr. Perkins, you're gonna sit next to Ms. Charlton in the first row. Cabanillas? Right, you're gonna sit in that first chair on the second set of seats, right there, the first chair, the first chair. Yes. Buendina? Is that Buendia? You're gonna sit next to Mr. Cabanillas? Right here on the first row? Ms. Benoit? There's a seat between you and Ms. Buena. Sit right here on the first row. And Ms. Carey, you're gonna sit next to Ms. Benoit? Ms. Sion, you're gonna sit on this first row next to Ms. Carey. Mr. Tompkins, you're gonna sit next to Ms. Sion. Is that Ms. Jahab? Gahab, you're gonna come in that second row, you're gonna walk all the way down to that first chair in the first set of seats. Miss Goodwin, come to that second set of chairs, you're gonna walk all the way down, you're gonna sit in that second chair. Mr. Mesquita. Mr. Godwin, second set of chairs, Mr. Godwin,
Okay.
you're gonna come to the second set of chairs and walk all the way down, you're gonna sit next to Miss Goodwin. All the way, no, second set. Behind him, this gentleman, yes, go all the way down, keep going. All the way down to the end with it. No. Sir, you gotta go all the way down. Yeah, down there. And Mr. Morales, you're gonna follow, was that Mr. Morales? Okay, so we have Miss, is that? Lottridge, okay? Just follow Mr. Morales, there's a seat between you and Mr. Morales. And False, you're gonna sit next to Mr. Lottridge. The camera has to be turned.
Yeah, let me.
No, come on, fix it. But now, you can let him know.
Okay.
Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for inclusion on a criminal jury trial. You'll be asked questions by the attorneys that are participating in this court. Now, the case that you have here in this court is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Now, your felony cases are normally referred to as your more serious type of criminal offenses. And whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, in this court, County Court at Law Number 2, we handle misdemeanor cases. Misdemeanors are divided into 3 categories. We have the Class A misdemeanor, the Class B misdemeanor, and Class C misdemeanor. Now, the Class C misdemeanors are cases that are handled in the JP court or the city court, and they come to this court when a person appealed their case in that court and it comes to this court. Now, for example, a speeding ticket or person not wearing a seatbelt could get charged with a Class C misdemeanor. Those are Class C misdemeanor cases. In those cases, the punishment is by fine only. That simply means that you cannot be given any jail time. It's just basically by fine only. And the fine cannot exceed $500. The Class B misdemeanor, the range of punishment for a Class B misdemeanor is minimum 0 days to maximum 180 days in the county jail, or a fine that does not exceed $2,000, or a person could be given both such fine and confinement. For the Class A misdemeanor, the range of punishment is minimum 0 days to maximum of 365 days, which in the county jail, or a fine that does not exceed $4,000, or a person could be given both such fine and confinement. Now, you have been asked to serve or on a jury in this case, and in this case, it's a little different. Normally, cases, we usually have single cases, but in this case, it will be 2 cases handled at the same time. They have been consolidated, put together. And the reason why is because they occurred out of the same criminal episode at the same time. Okay. And so you will be examined for inclusion on this jury trial in this criminal case, and our courtroom hours normally vary. Normally the courtroom hours is from 9 to 5 p.m. But we usually have large dockets in the morning, and when a docket is a list of cases that we handle. And so we handle those cases. We have, like this morning, we had an arraignment docket where individuals who is coming to the court for the first time, we call it arraignment initial appearance. And sometimes those dockets usually go into lunch or sometimes a little later. And so we usually have our trials start at 1:30 in the afternoons. In this case, which is the first day of trial, we're picking the jury. And the reason why this case did not get started at 1:30 is because a legal matter had occurred and it had to be addressed prior to the start of this trial. And so legal research had to be performed. Okay. And that was done And so, whether or not you are selected as a juror today in this case or in these cases, you are serving or performing a significant service which only free people can perform. If you are selected, this case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless otherwise instructed, you will be permitted to separate yourself at recess, for meals, and at night. Now, before we go any further, I must perform the first of two administrative duties. The first administrative duty that I must perform in this portion of the trial is called, I need to give you an oath to impanel you as jurors. And so at this time, I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, I do. Okay, everyone, please raise your right hand. All right. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching your service and qualifications as jurors? So help you God. Please say I do. Okay, you may put your hands down. Now, the law requires that each of you must possess certain qualifications before you can serve as a juror in this case. Also, there's certain excuses or exemptions that you may wish to claim. First, I would like to determine if you possess the qualifications to serve as a juror in this criminal case. It is very important that you answer each question truthfully. If you do not, and the lawyers or I discover this fact after you have been seated on a jury, this case could be retried. Why? Because a mistrial will be declared. And you may be held in contempt of court, which means that you can be placed in jail up to 6 months and given a fine that does not exceed $500. So I will first determine if everyone on the panel is qualified to serve as a juror. Now I'm going to ask you some questions, and the way I'm going to ask the questions is as follows. I'm going to ask a series of questions, and I do not want you to answer those questions out aloud. Just answer those questions to yourself. And then once I ask the last question, I would then ask you, is anyone disqualified under the law? And if you think that you may be disqualified under the law based on the answers that you gave to one or more of the questions, I would ask you to please just raise your right hand, and then we will discuss that matter outside of the presence of the jury. And when I use this term, or when I say outside of the presence of the jury, what I mean is this. First of all, we are airing on YouTube. I will turn off the YouTube. I will turn off this microphone. I'll turn the microphone off. And then I have a noise sound device that sounds like this. And then we would ask that you will come up before the bench. You're going to stand on this side of the bench because we have some microphones. And the microphones are here for our court coordinator, for our court reporter to listen so that she can hear what's going on. All right. And so that's for individuals who will like to make statements outside of the presence of the panel. Now, I'm going to start off asking the questions. As I mentioned to you earlier, please answer those questions to yourself. And then at the end, when I ask, is anyone disqualified under the law? And I ask you to raise your right hand, and we'll ask you to come before the bench. And you'll stand on this side of the bench. All right. First question, except for failure to register, are you a qualified voter in Jefferson County and the state of Texas under the laws of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause at this next question, and I need to inform you that I'm required by law to ask this question. I'm not trying to pry into your personal affairs. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a resident of Texas and a resident of this county? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? That was the last question. Now, is anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. Okay. Let the record reflect that no one on the panel raised their right hand. Now, I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just remain seated. Now, I will ask these questions in the same manner that I asked the previous set of questions. I will ask a series of questions, answer those questions to yourself, and then at the end, I will ask you, is anyone on the panel wishing to claim an exemption? Now, an exemption is, you can claim it if you want to, but you do not have to. All right. First question. Are you over 75 years of age or older? Do you have legal custody of a child or children under the age of 12 and jury service will necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the 3-year period before today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed to a location away from your home station and out of Jefferson County? If any of these exemptions apply to you and you do not desire to serve as a juror, please raise your right hand. Okay. We have juror number 9. Okay. All right. So at this time, juror number 9, would you please come forward? Okay, is there anybody else? Okay. Let the record reflect that the remaining members of the panel will not be claiming an exemption. I will now move to excuses. Now, under excuses, I'm not going to ask you a series of questions. Actually, I will make 3 statements. And if any one of these statements apply to you and you would like to be excused, just please raise your right hand and then we will move forward. The first question, not the first question, but the first statement. A juror may be excused for observance of a religious holiday upon the completing of an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. Number 2, a juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the defense and without the consent of the state. Final statement. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel, anyone else on the panel who will be claiming an excuse? Let the record reflect that no one is claiming an excuse. No one else on the panel is claiming an exemption. And at this time, all members of the panel is qualified to serve. Let the record reflect that the time now is 2:51 p.m. on today's date, June 6, 2025. Let the record reflect that the court is in session in 2 cases, cause numbers 24 CCCR 2011, cause number 23 CCCR 0642. Both cases are styled in the state of Texas versus Alan Valdez. Let the record reflect that Mr. Valdez is seated at council table with his attorney, Attorney Glenn Crocker. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Andrew Hillble, and Attorney Shane Hilton.
Good afternoon.
Again, ladies and gentlemen of the jury, you have been summoned to this court to serve as jurors in a criminal case. Our court reporter in this case is Miss Ada Christie. She's sitting to my left. She will be taking down everything that is being said, so speak up when you are answering or asking questions. The bailiff is Miss Brenda Mosby. You met her earlier. The defendant in this case, or in these cases, are charged with fleeing a police officer and unlawfully carrying a weapon. The state and the defendant, through their attorneys, have the right to direct questions to you concerning your qualifications, backgrounds, experiences, and attitudes. In questioning you, they are not trying to meddle into your personal affairs, but they are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of a panel, just say so, and I will ask you to come up before the bench so that we can discuss the matter more privately. Is the state ready to proceed?
State's ready, Your Honor.
Is the defense ready to proceed?
This is ready, Your Honor.
Mr. Hubel, the panel is yours, and is 30 minutes enough for each side?
Yes, Your Honor.
Okay. I'll be keeping time. You may proceed.
Thank you. Good afternoon, everybody, and thank you for being here. Both the state and the defense appreciate your time and consideration in this matter. Now, what we're here to do is to conduct a process called voir dire. Most people just refer to it as jury selection, but there's some meaning behind the words and that it needs to speak the truth. And that's all that myself and Mr. Parker are asking you to do in this process, is when we ask you questions, give us truthful answers. There are no wrong answers. We're just trying to make sure that we can, select the best jury for this case. In juror number 3, Mr. Rhodes, I think you'll agree with this statement that, we definitely need to hear your opinion, and being quiet is not the way to get a jury selection, right? Because it's a deselection process, not a selection process. Both sides, both the state and the defense will, strike a certain amount of, potential jurors, and then whoever's left, out of the first grouping of you will, be the jury in this case. So the more we know about you, the better. Now, who wants to answer our opening question? Any volunteers? Alright, juror number 20, the question that I'm going to ask you is, if you saw an officer driving in front of you in a marked police vehicle, and he has his lights on the other side of the road, what would you do?
Over safely to the side.
Okay, does everyone agree with that answer? Good. Anyone disagree? Alright. So, and juror number 20, what would be your reasoning for doing so?
Fear.
Hey, it's a fair response. Does anyone agree with that? Alright, and someone who has a different answer than that?
That's the law.
That's juror number 15, Miss Gayhill? Right. Anyone agree with Mr. Gayhill? I mean, Mrs. Gayhill's answer? See a lot of shaking heads. So getting into the law that controls the case, the statute for the difference of fleeing a police officer is in the transportation code, and I'm just going to read this blurb deal. A person commits an offense if the person operates a motor vehicle and willfully fails or refuses to bring the vehicle to a stop, or flees or attempts to elude a pursuing police officer when given a visual or audible signal to bring that vehicle to a stop. Meaning that the elements of the state which have to prove to you in this case are that it occurred in this county, in Jefferson County, on or about a certain date. The defendant was in fact the individual who did it. That they were operating a motor vehicle and they willfully stopped while a police officer in uniform in a marked vehicle gave an audio or visual signal to stop. Or gave a visual signal to stop. And so juror number 1, after that explanation, can you tell me what you think that this looks like in property?
Behind you, has their lights on, 4 sirens, and we got a pool over.
Okay. And in your head, how long does this generally occur? Like, how long does the individual willfully refuse to stop in your head?
5-ish minutes, so we can safely go over.
Okay. Anyone have any different ideas about how long in their head that they would see this occurring?
I believe it's subjective.
Okay.
It depends on a bunch of different factors.
Okay. So if I'm understanding what you're saying, like in certain circumstances it might be 5 minutes, for certain circumstances it might be 30 seconds.
It depends on how they're driving, if they went through any red lights, if they were unsafe while doing so, the length of the distance along with the time. I think all that's factored in.
Okay.
To be safe enough to pull over. Can't
Right. Okay, so that's it. So something that you would be looking at, if that's during the states, Ms. Charlton. You'd be looking at if there were potentially places for the individual to stop before, like while they were locally refusing to pull over.
Yeah,
Okay,
sometimes you just don't know these days, so who's trying to pull you over?
I'm sorry.
So you don't always know, like, if the person who's trying to pull you over is like exactly legit or not, even if they look legit, you know?
Okay,
So you wanna make sure you're in a safe, well-lit place, you don't want anyone getting hit by a car.
all right. So safety is a concern for you. Okay. And does anyone else agree with that? I,
I agree, but there's the element of the condition the person is in. There might be a heart attack, there might be some mental, things going on that emotionally they're distraught or, whatever, condition it is that you might not pull over immediately.
so there are certain situations where there's an emergency.
Yeah, or even, for, say, a woman on a dark piece of highway, why would they wanna pull over for just anything? Even if the police is flashing behind them, that's still a scary situation.
I would agree. I also think it also sort of depends on race, who might be a bit more scared.
My
Okay.
thought would be that, first of all, I'd like to know, are they actually behind me? Are they pursuing me? And then try to find a safe place to move over and see if I am that they're pursuing.
So potentially, are there any other vehicles on the road that the officer could be wanting to pull over?
Right.
But you're less likely, would you be less likely to be concerned about that if the road was empty?
If the road was empty, I wouldn't be concerned, but I would be concerned in my head, what did I do for lights to come up behind me? Well, unless you're, driving and have road construction, you have to take consideration about that, because sometimes you have to soft shoulder to stop one.
And you especially take that into consideration, right? You're number 19 because you're a trucker.
Yes, sir, correct.
All right, so. Does anyone else have any input in regards to that particular, discussion we've been having so far? Right, and juror number 2. When thinking about this kind of offense, how fast do you envision the driver going?
Over the speed limit.
Okay. So you envision them going at a higher speed? All right. Juror, juror number 30, would you believe that's necessarily the case in all these cases?
No, not at all. That would be felony evading if they're speeding. This is gonna be class B, attempting to elude, which you can just drive longer than necessary and not pull over. And you're attempting to elude. I think the one thing that isn't really thought of is the amount of cops that are coming to stop this man that is not pulling over. Those officers don't know if he's setting up an ambush, they don't know what's happening. Multiple cop cars come behind this one guy. All these squad cars are in different locations in Jefferson County to make sure everybody's safe. He's taking the focus of all those cops onto one person. What happens if some other crime happens on the other side of Jefferson County while this guy's not pulling over?
And that's exactly right. It's creating Ms. Charleston and Mr. Pulse, y'all were both talking about the safety situation. There's an equal and opposite reaction in those kind of situations that create a safety situation for both the officers and the community. Does that make sense? Yeah. I don't,
It depends how safe you feel around police officers, I guess.
okay, I understand that. And I think, juror number 3, Mr. Rose, did a great job in answering the next question I was going to ask, which is why this offense exists in the first place. To protect community safety. The certain issues regarding an individual who's refusing to pull over for an officer are that they might be destroying evidence, they might be preparing to fight with law enforcement, they might have a weapon in the vehicle. And they might be on the call with someone else who's going to be showing up at the scene to cause trouble for law enforcement. Or in the end, it could turn, as Mr. Rose pointed out, into a full-scale felony evading. So with that in mind, Ms. Johnson, juror number 4, do you think it's important that the state prosecutes these cases?
Yeah, I think so.
Okay. And this is a scale question, so I'm going to ask you to each of you think of a number in your head for this question, and I'm going to go one by one to ask you what that number is. Everybody do that? And the scale is from 1 strongly agree, 2 agree, 3 disagree, 4 strongly disagree. And juror number 1, what's your number? 2. Juror number 2?
Same.
Juror number 3?
1.
Juror number 4? 2. Juror number 6?
Yes, 2, I'm 3, I don't know.
Okay, and that's fine. If you had to settle on an answer, do you think you could pick between those two?
I mean, the word important, like how,
And how important is it?
that's not the most important thing.
Okay, so you would land more on 3?
Yeah.
And juror number 7?
2.
Juror number 8?
I don't think we have enough information to properly answer this. So I'm between the 2 and the 3.
Okay. And what do you, and can I ask, what do you think you're like, what do you think you're lacking in, regards to being able to make a decision?
I don't know what the circumstances were that caused this man to get pulled over.
And I'm not asking about the specific offense, in this case, I'm asking more, like, is it important to the state prosecutes this kind of case?
I don't know. I mean,
Okay.
with the information I have, I don't know. So,
Alright.
3.
All right. Ms. Benoit, juror number 11.
2.
Ms. Carey,
2.
Ms. Sheehan,
Same one.
all right. Mr. Tompkins,
2.
Ms. Gayhead,
1.
Ms. Goodwin,
2.
Mr. Morales Diaz, and Mr. Lufford, 2. And Mr. Bolts.
To say too, but there could be extenuating circumstances that would negate that.
Okay. And then, this next question is also a scale question. And I'm asking what your general, feelings towards law enforcement are. Or do you have, are they positive? Do you, number 1, strongly support law enforcement, 2, support, 3, disapprove, or 4, strongly disapprove of law enforcement? Juror number 1.
2.
Okay. Juror number 2.
Well, it's a cross between 2 and 3, just from personal experience.
Okay. So for you, it would depend.
I do believe in the law, but yet I have experienced things that were not, the police were not.
Okay.
That way.
All right. Let me ask you this question. If the state called a law enforcement witness, would you be able to independently evaluate their credibility? And, okay. And you can still be fair and impartial in a case where the state brought law enforcement witnesses?
Yeah, I think it is.
Okay. Juror number 3?
2.
Juror number 4?
2.
Juror number 6?
Shocking. 4. Too much police brutality.
Okay, and like I said, there's no wrong answer. We want your full
You
opinion.
know, just being honest.
So juror number 7?
2.
Juror number 8?
2 for some departments, 3 for others.
Okay. Can I ask you to elaborate on
Yeah, I support law enforcement, but I don't support every action that law enforcers take.
that? Okay. Juror number 11? Juror number 12?
3.
Juror number 13?
1.
Number 14? Number 15?
1.
Number 16?
1.
Number 17? Number 19? 2. And number 20?
2.
And coming back to juror number 2, Mr. Meyer, can I ask you, you said that you've had negative experiences with law enforcement. Do you mind expanding on that, or would that be something that you want to talk just amongst the attorneys? Okay. We can do that. So we've talked about the law strength in this case. Now I'm going to generally speak on the rights that are afforded to defendants in these kind of cases. They have a right not to testify and to remain silent. You cannot hold that against them. Can everyone agree to that? Okay. And it's essentially just like how being arrested and being charged with something does not equal guilt. It's my burden as the state to prove each and every element of the case can be guilty. And that's based on the defendant's presumption of innocence. And unless I so prove those elements beyond a reasonable doubt to you, then you must vote not guilty. But if I prove those elements to you beyond a reasonable doubt, then you must vote. And that burden I was talking about just now, beyond a reasonable doubt. Let's see, and not yet spoken to juror 7 very much. Do you think that myself or Mr. Crocker can give you a definition of beyond a reasonable doubt?
You can try.
Actually, we can't. We can't try. We can't even attempt to give you one. It is each and every one of your personal standards of what beyond a reasonable doubt is. What we can tell you is what it's not, and it's not the law and order standard, like of not beyond a shadow of doubt. It's not beyond all doubt. It's not absolute certainty. But what we'd ask you to do is to use your common sense. You don't check it before. Whenever you see it, you will know. The law will guide your decision in these cases. You'll be provided with a charge that will explain each and every element to you. And you can evaluate based on the testimony and exhibits that are in trial, whether or not the state has proven that to you beyond a reasonable doubt in your own standard. Can everyone do that? Thank you. Now, juror number 8. With this being a fleeing police officer case, what kind of evidence do you think that the state would bring to prove this case beyond reasonable doubt to you?
I don't know. I assume you do not have a police officer.
Okay.
If he has a dash cam.
Okay.
You have a body camera. That's what we do with that. I don't
Good, those are good answers. So we would have testimony from responding officers. They would have dash cam and they would have body cam. So those are all great answers. Juror number 11, can you think of anything else that the state might bring to prove its case?
No, not really. I don't know what he says.
And just kind of going back to what I was saying earlier during the burden of proof section, that the state's going to be bringing evidence and testimony exhibits. We're asking you to only consider what is admitted, that testimony and evidence. Or those are the only things you can consider in making a decision in this case. Now, I'm gonna stick with you, juror number 11. So, witness credibility. Let me ask you, when a witness takes the stand, what level of credibility do they have?
I would think that they would be. I would hope that they would be truthful and that they would,
Okay.
be able to.
But that's something that you have to evaluate once you start to hear what they have to say, right? Okay. So would you agree with me that every witness starts out before they speak anything, they start out with equal credibility?
Yes.
Now, whenever you go to evaluate someone's credibility, what do you look for? Interesting. So do you have kids?
Yes.
All right. If they come to you and start telling you about something that happened, are they always truthful with you?
Well, they're all adults now, so.
Oh, whenever they were younger. Were they always truthful with you?
I would say yes, they were. And the only way I would know that if they weren't was they really couldn't look me in the eye.
Okay. So, do you think that if you were listening to someone, speaking to you, you would be able to, generally tell if they were telling the truth or not, just based on how they're talking?
That still would be part of, I'm not sure, but not sure about that.
Ms. Carrier, how do you feel about that question?
It is hard to tell, I guess, just depending on the person, maybe like speech patterns or, how fast they're slowly talking, and how long it takes to answer something.
And another thing that might be worth consideration, just if their story makes sense, right? Okay, based on what you've seen or heard, elsewhere, if their story lines up. Would you agree with that? Okay. So this is another area where I would ask all of y'all not to check your common sense at the door, to look at each individual person who's testifying, look at what they're testifying to, look at the, exhibits they get admitted into evidence, and essentially, see if the story lines up. That's how you would determine, your credibility of the witness. Would you agree? Okay. And let me ask you this question as well. Law enforcement witnesses. If the state calls a law enforcement witness in this case, and they take the stand and you're listening to them, do they start with, more credibility, less credibility, or equal credibility to any other witness for you? Okay. Does anyone feel differently about that question? Okay, so every witness who takes a stand, regardless of whether they have,
I'm sorry, I was fixing my glasses.
okay. Regardless of whether they have law enforcement experience or they're some kind of expert in something, they would all start with equal credibility for each and every one of you. So, another responsibility, that you will eventually have in this case is considering punishment. This plea, this plea case is, a Class B misdemeanor. The defendant in this case would be subject to, 6 months in jail, up to a $2,000 fine, or up to 2 years probation. Does anyone have an issue with considering this punishment range?
Mr. Yeah. I'm gonna say, hold on.
Law surrounding the police officer. Case, we take up the law surrounding the second case, which is an unlawful carry of a weapon case. All right, so this time to talk about guns. The statute in this case is incredibly verbose, so I'm just going to read it for you quickly. A person who has an offense, if the person intentionally, knowingly, or recklessly carries on or about his or her person a gun in a motor vehicle or watercraft that is owned by the person or under the person's control at any time in which the person is engaged in criminal activity other than the Class C misdemeanor, is a violation of a law or ordinance regulating craft or boating. Essentially, if you have a gun on your person in your car on a right person in your car while you're committing an offense that's not a class C, which class Cs are, essentially traffic offenses. Then you are committing an offense. Does that make sense to everyone, or, does anyone need explanation or clarification?
It's supposed to be.
For that?
Are you allowed to have the gun if you're not?
Right, you are.
Okay, so I thought there was some sort of like, your the car extension of your house law or something. No.
The, like. The conduct here requires you to be engaged in other criminal activity. So,
Okay. So it was okay until what?
so, and just based on what you're saying, you have concerns about this specific type of offense.
Okay until it's not, then, okay.
And let me kind of stick on you for a bit. Can you think as like what the purpose is behind a law like this?
Well, I assume that they just want to get you on more charges. But if you have a weapon, I mean, it's very fun stuff that I guess. Maybe, I don't know. I think it's having a gun in your car and it being okay. Like unless you're brandishing it, I don't think it should be an additional charge.
And again, I appreciate you being so candid. But juror number 13, can you think of what the reason behind this law would be?
It's okay until something happens.
Right, and
I
that's
think
something,
everybody should be carrying a gun.
that something happens is the concern here.
Right, I know.
And firearms can increase the danger of certain objects. Specifically in this case, we have the offense that we talked about earlier, which is class B misdemeanor, the police officer. And in that situation, can you see the type of danger that might occur with what?
Well, complaint.
And well, juror number 14. What, can you think of what the concern for a responding officer might be if there's a firearm in the vehicle while someone is slow rolling from them?
He's wanting to get away bad enough. What's stopping him from doing it, because usually
That's exactly right. And for anyone concerned that this is like, that they are going like 60 and a 45 and then and they're pulled over and suddenly suddenly the gun that you're lawfully carrying becomes another offense. That's not the purpose of the statute. These are the elements that they have to prove very quickly. In Jefferson County, on a certain date, the defendant intentionally carried on a person that handgun and loaded it into the defendant's control. The defendant was then in there engaged in criminal activity. So in this case, police officer.
Mr. Hubel, you have a minute and 30 seconds. If you need more time, just let me know.
Okay, I should be able to wrap up pretty quickly, Your Honor.
Okay.
But yeah. So this is not, the purpose is not targeting someone that's being ticketed and suddenly their otherwise lawfully held gun becomes a class A misdemeanor.
I just care if
No, I
using it or not. Light, could it just be lighting?
okay, so with that in mind, with that explanation of the law controlling in mind, is there anyone who, when if the law contained in the court's charge in this case, presents this as an offense, is there anyone who couldn't follow that law? Okay, I see no hands coming up. Does anyone need any clarification on that question?
Yeah.
Okay, so at the end of this case, if you're selected as a jury, you'll be given a document called the charge. And that will contain all the law involved in this case. And you'll be instructed on the law surrounding UCW as well, or unlawful carrying of weapons as well. Will you be able to follow the law in that instruction as a juror?
Yeah.
Okay. Juror number 20, you said yes. Okay, juror number 6,
mean, I don't disagree with it, but logically, I guess I have to follow the laws.
Okay, but, and logically, yes, but would you be able to?
What do you mean?
And
I don't, is that like contempt or something?
I mean, I just need a yes or no.
Well, I guess I have to say yes.
No, you don't. You actually don't. If you don't feel that you can follow the law in this case, then a perfectly valid answer is no, I don't think I can follow the law. All I need is your honest answer.
I don't know.
Wouldn't that be depending on the circumstances that's presented? You know, because there's sometimes when a law is just not appropriate. It's a circumstance that's more appropriate.
Right, that'd be something for you to consider. But what I'm asking is, would you, if you're so principally against it that you couldn't even consider the facts of the case?
Well, I'll say yes so that I could probably defend him.
Are you, real quick? It says, with that in mind, if given a charge, are you referring to the court's charge at the end
Yes, sir.
that has the series of definitions and
That
instructions?
is correct.
Could we follow those instructions?
Yes.
Yeah, so you're not referring to whether or not we would automatically
Oh, no,
find
no,
guilty or,
I'm not asking that.
okay, yeah, so. And I think that might, because that was confusing me.
Yeah.
He's not referring to, would you find this man guilty? It's, could you follow the instructions given by the court?
Great instructions.
Okay. So, in, just some final general questions before, I pass it down to Mr. Crocker. Is there anyone who would have difficulty sitting in judgment on the lawyer? For either religious, philosophical reasons, any reason? Okay. And is there any reason that any of you can think of that you cannot be fair and impartial in this case? Okay. Is there anyone in here who knows either myself or Mr. Hilton? That knows Mr. Crocker or the defendant, Mr. Valdez? And are there any questions that you would have for me? Because this is the last time that we can speak back and forth like this until the end of the trial.
Who was the police officer, do we know? I have family in, it's police, I just want to.
Any judgments to me?
I'm gonna ask me, or you know.
The officers in this case are Officer Justin Flanagan, Officer Craig Murphy, Officer James Greason, and Officer Jared Genesee. Is anyone familiar with any of those officers? All right. Thank you all very much. We appreciate you taking part in this process. The justice system does not work without you all.
Mr. Proctor, you have 33 minutes. Mr. Hubel took 13 minutes.
Good afternoon. You might wonder why they're picking on number 3 so much. He's an assistant district attorney in Orange County. It's the field. I promise it's all random. It's not even difficult. Well, well, it's unusual that we have prosecutors, current prosecutors. We also have another lawyer here, a civil lawyer, and we have 2 people that work for law firms. We've got Ms. Carrier and is it Gahab?
Yeah.
And you work for Mahaffey?
Weber, yes.
Anyone else that is? Okay, that's unusual that we have that kind of wonderful breadth of law experience. So I'm gonna kind of a little bit to the chase. If one of the lawyers or legal support staff gets selected, they're prohibited from telling you their definitions. We are controlled by what comes from the bench in the form of a charge to the court, and you heard number 8 briefly talk about it. We're familiar with it in the legal world, but it's a piece of paper that essentially says, these are the definitions, you can't make your own. This is the law. You can't make your own. If you have any questions, you gotta ask the judge. Full procedures and stuff. All right. So I think it's interesting that between number 20 and number 6, there may have been either a confusion as to whether you could follow the law, whether you didn't like it or not, or whether or not the charge, i.e. the questions and instructions, bound you to a certain decision. Is it the length? You're afraid that what comes from the bench may say you must rule this way, you don't have any discretion?
That makes sense.
Okay, because there's a concept out there that's kind of a novel concept, it's called jury nullification. Where you get someone back there who says, I don't care if they're guilty of sin, I don't like it, and I'm not gonna vote guilty. That's nullification. You gotta follow the law, whether you like it or not. That's what the purpose of the question is. Now, I know this, some people are better jurors for particular cases than others. I try felonies and I try misdemeanors and I guess anything in between, if there is anything in between. And some folks will say, I would never be a fair juror sitting on a sex case. Something maybe an offense against a child. But yeah, give me a DWI all day long, I can sit in judgment. Or I can't sit in judgment of this, but I could on this. Is there anyone here that has had just generally a negative, other than number 2, that you experience with law enforcement that would say, I can't be fair? Okay. Now, who is it that has the son that is an officer? Yes, and you are number?
16.
You're 16.
Mm-hmm.
Who does your son work for?
Fort Natchez.
Fort Natchez, okay, so he's not involved in this?
No.
Well, how do you know? Have you talked to your son? Son, am I gonna be sitting on your jury next week?
No, my son was a police officer. He's no longer.
Okay, so you're still on. Who has the MP in their family? Number 1? Who's that?
My brother was an
Was an MP. Is there anyone here that is current law enforcement in their immediate family? No.
Arthur PD.
Port Arthur PD? Okay. That's your son?
Sister.
Sister, okay. All right. Anyone here by a show of hands had an ambulance or a fire truck sneak up on you and you look in their very, you get over it? Anybody? Show of hands. Well, they got the lights going. They've got the sirens going. What happened there, folks? Anybody? Which name?
Tompkins. There.
What?
Just wasn't paying attention.
They snuck up on me, right?
That's when there's something in the car.
That's with the radio, maybe on the phone, even though we're not supposed to be. Never, right, right. Ma'am?
That all the songs have sirens in them these days.
You get sorry, but. Has that happened to anyone on this program? Not on the second. Yes. All right. Is that a crime?
No.
Look up, get out of the way. That's why you need to move. That's what they're saying. Move over, get out of the way. We got someplace to be. Has anyone had a cop slide up on them? You're like, oh God, they're behind me. You pull up with the cop and run around you.
Yes.
And then you go, all right, I'll live to fight another day. Right. Snuck up on you, right? Were you evading then or eluding? It's kind of fact specific, isn't it? It's not just because an officer was behind me. An officer was behind me with lights. An officer was behind me with lights and perhaps an audible source, i.e. siren or more. There's more involved. Wouldn't you agree? All right. Why do police cars and emergency service vehicles have audible signals, horns, sirens? Anybody?
To alert you.
Should the lights enough, right? Okay.
Can hear it from a distance.
One more time.
Can hear it from a distance.
I can't hear you from this far, that's why I'm saying one more time. You have to speak up. Oh,
Yeah.
I can hear you from a difference.
You might not see the lights around the corner, but you hear it.
Sometimes that's what makes you look up and say, oh, they are behind me. Right. You know, when you see emergency signals, that it's a police officer, an ambulance, a fire truck, or other type of vehicle, anybody.
The red and blue are cops, right?
Correct?
Red and yellow fire.
Right? You want to agree with that?
I see those lights.
Well, what did you say?
I'm not sure.
I can see why.
I just, you never have to agree with that, agree with this, yeah, remember? Yeah, you just see lights. And I go, hey, is that man, is that a fire truck? I know it's not the pizza guy, right? It's somebody. So we gotta discern, who are they? Who, if anybody, are they after, or where are they going, right? So I have to mentally, as a driver, make some decisions, right?
Well, you can tell if a fire truck's coming up behind you or an ambulance.
You can hear, can't you?
And you can see when you get
Right.
down. Yeah.
Gonna bring you back a little while ago. Infamous, but a wonderful example. White Broncos, what do you say? Who's? And OJ was what? He wasn't driving, was he? He was riding and it was, what did your people say? A slow roll. He wasn't doing 90, was he? His partner was AC Callums, was on the phone with the police saying, hey, this guy's gonna kill himself. I gotta keep on moving. Is that eluding arrest? Anybody? They are last year's, well, it depends on the circumstances, they're emergency. That situation, would that be an emergency? Don't know, we know this, it's fact specific, correct? Just because you're not speeding may not mean you're not eluding, but just because you're not stopping doesn't mean you may not be. Come on, people. Thank you, eluding. Reasonable doubt, we used to be able to give definitions, we can't anymore because we leave it solely to the trier of fact, and the trier of fact is the jurors again impaneled in that box over there. We say don't leave your common sense at the door, I think that's a wonderful, wonderful watermark. I also think it's type of doubt that would make you hesitate when deciding something of the most important affairs of your life. Do not hesitate, always sure. As Mr. Valdez sits here now, is he guilty or not guilty?
He's not guilty at this time.
Presumed innocent.
Or, yeah, presumed innocent.
Everyone agree with that? So we vote right now, what happens? Guilty. One more time.
Innocent till proven guilty.
Innocent till proven guilty. So, where do we hear the stuff where we put our minds to work and say, well, I heard this and I heard that? Where does that information come? Here, the stand. What I say, what Mr. Hubel says, what Shane says, is not evidence. Who should be the ones delivering the evidence then? What is this? He asked me, is it okay if I ask who the cops are? Sure, I wanna know, is that your cousin? I wanna know if it's your next door neighbor. So we know this, the evidence is gonna come from here, from officers, right? Okay. Who says, man, after I hear those 3 or 4 officers, I really need to hear from Alan, wanna know what was on his mind that night? Anybody?
Yes.
Yeah,
Yes.
yeah. You're number 20, Mr. Holmes.
Yeah,
Okay, tell me about that.
well, I mean, everyone has a right to defend themselves
Mhm.
and have counsel such as you, but also to call their own witnesses if they have somebody else that may have observed the situation. Yeah.
What do you think about someone that just doesn't avail himself of that, just sits there and lets his lawyer do the questioning and that's
He
it?
has that right to do that as well.
But does that,
That doesn't mean he's guilty. That means he's maybe smart, really, to let the lawyer handle that situation.
so there's nothing about that that in the back of your mind says, oh my God, if that was me, I'd be up there saying, ask me more questions, I got plenty to say. Right?
I mean, sometimes keeping your mouth shut is the best. You know.
I like to think burden of proof is kind of like a scale. You know what my burden is? Nothing. You got an easy job. You don't have to do anything. Sit there and scribble on your legal pad and look intelligent. Necessarily true. Here's what I know that the state has the absolute burden to present evidence. Where's it come from? From the stand in the form of what witnesses? And it must convince you at the end of the day that beyond a reasonable doubt, the crime was committed. Now, if anyone here says, yeah, but to give Alan a fair shake, I would need to hear from him. I need to show of hands. Anybody? Yes, ma'am, Ms. Carey. You're saying, look, Mr. Valdez, if I'm gonna give him a fair chance in court, he's gonna need to testify. Yes, knowing he doesn't, you have to, right?
Oh, no, he doesn't have to, but if he chooses to do so, I would like to hear from him.
You would like to hear from him, I understand, but would you hold it against him? Okay, that's a terrible lawyer question. Who do you work for?
Not a carrier.
Ms. Carey, okay, are you her lawyer? Okay, yeah, so you know, mom asks bad questions sometimes, right? Or confusing or confounded, right? Okay. Anyone else gonna require Alan to come testify? So I'm not gonna dwell a lot on the gun issue because I really like the way you said it. It's not an issue till it is. It's a wonderful way to put it. And I've always said, look, you can't get to unlawfully carrying a weapon unless and until you find him guilty of some criminal offense that is not the gun. I like what she said better. I'm gonna steal it from you. You're a teacher?
Professor, yes.
Professor, where do you profess?
Oh, a little more for right there.
Wonderful. In what subject matter?
English.
English. Okay.
I disagree with, it's not illegal until it's legal, or it's legal until it's unlegal, or not.
You disagree with that?
As in, I mean, drinking is completely legal until you get in a car. I mean, everything has its limit and then it becomes illegal. So it's not some one and done type thing. This isn't a rarity. It's in the law everywhere.
That's specific to this case.
Well, I'm just saying, you know, you can take drugs that you're prescribed as soon as you get behind the wheel, you know, if you do something that's causes the death of somebody else, manslaughter, all that. I think that there's a lot of things that are completely illegal if you do something and they are illegal. That's how the law works.
Okay. Why would someone elude the police? Somebody tell me. You're looking at me, you get paid.
Well, I mean, I guess, if this person, maybe, I don't know if they had an outstanding warrant, they could have, maybe been worried. if they did something to do something away from somewhere, you know. Or just, you know, kind of go into a state where you just don't think properly.
Now, if I see the police behind me or lights, then I decide, let's see how my car will win. That's a little different than.
Oh, yeah, that's.
Back there. You pull over, right? So in that last scenario, why would someone do that in your mind?
As far as the accelerating,
No, not accelerating, just kind of keep on going.
oh. It wasn't a good show.
Okay. So it's so.
You don't wanna, I mean, I see a lot of people pulling over lots of times on freeway with construction. I think it's a bad idea. I think you should wait to take next week. We put the officer in danger. We hear it every few years. An officer getting hit by people not paying attention to vehicles pulled over. I mean, safety conscious. And there's a lot of reasons about hearing any facts. It's kind of hard to.
Where the sirens on,
One more time.
where the sirens on.
It's heavily factual, it's conditional on the fact. Anyone live in North Jefferson County? No?
I'm not from Texas originally, so what is,
I would say north of Parkdale Mall area. Close.
No.
Nobody, nobody? You're on mid county, South County folks?
Jerry's out here.
I grew up there.
You grew up, what part of town? You grew up?
Oh, you know, between Lumpton and Beaumont, and then Beaumont, Lawrence Drive.
Okay.
North of Beaumont.
So we're talking about a particular piece of highway, essentially just north of Tram Road to an exit south of Lumberton. Is anyone familiar with that stretch of highway? Okay. So when you start using terms, maybe some street names, there may be some familiarity. Okay. Does anyone drive that route routinely?
The best.
As but not routinely. Okay. How far do I need to drive before I'm eluding? Well. Anybody. There's no wrong answers. You just kind of get a feel here. Oh, yes, sir.
Can you repeat that?
Yeah, how far does someone need to drive before they are eluding?
It's subjective to the police officer.
Oh, it's subjected to the police officer. Does that mean that the officer's opinion binds the jurors?
Well, give you a scenario, I drive on it, so,
Yes, sir.
you going through the new construction going to Bridge City, the new bridge they paid for. If you was doing something and have an incident or whatever, there's no way you can stop. But if they throw your lights on, you have to go slow, but you go from Park Bridge or something, all the way to, you get to inside this Bridge City. There's no really no soft shoulders, so you have, when it be eluding, if you need to get coming down the bridge, because you can't stop until you get to almost to one of the liquor store is into the new what's hotel right there. You know, you can pull over safely and order to them. So it's subjective to the officer because he or she will tell you, you know, you went too far. You don't know because once they throw lights on you, and me, I get stopped sometimes for a DOT inspection. So when I see it, I make a decision when they throw lights on me, if I have room to go over, because the truck's so big. But also I make sure that if they are doing this inspection, stop, I gotta make sure I stop, put them out for those speeding, because perhaps a friend of mine, he didn't. And he's on the radio and had for speeding because while he was pulling over a car, he kept going speed limit, because there's only 2 lanes.
Yeah.
So a lot of things you gotta take consideration when you see them doing the stop, also when they putting you on for a stop, to make the right decision where you're gonna pull over to. Because if not, it's unsafe.
Who agrees with that? Okay, it's common sense.
Sometimes you can't pull over right away.
Yes,
Sometimes you can't. So coupled with, are they after me? Oh gosh, they are after me. Let me see where I can pull over. What's happening that entire time? Huh? And distance. Huh? And distance. Right? Right. So is it safe to say for members of the potential panel that there is no defined distance in your mind that says, after this mark, without a doubt, it's eluding? Reversal. Is there any distance in your mind when you're like, and no day on no planet is it eluding? You understand the question? It seemed brilliant. I don't know that it was.
They pull over immediately.
Yeah, am I supposed to put both feet on the brakes, lock them up, smoke the coffee, only get rear engine? As I go to the far inside shoulder, because it's the only one open. It's ridiculous, right? There's something between that ridiculous and OJ ridiculous that you're comfortable with saying they're just trying to get home. Yes, ma'am, Ms. Gary. There is.
I don't have a specific like answer, but there's something between that, you know.
Sure. And once again, what we all agree is based on the facts. Yeah, no. No, absolutely not. So this pupil said, this is a process of deselection. Mr. Rhodes. Oh, right, that's totally no. All seriousness, this is a serious matter for Mr. Valdez. This is a serious matter for me, and this is a serious matter for the state. The state wouldn't put their resources into it. Mr. Valdez wouldn't put his time, money, and resources into it and tie up the court if it wasn't serious for both sides. We know this, that we both have a differing opinion on what the outcome should be. I think it's pretty clear what we think the state should be, what I think it should be, but at the end of the day, that's why we have you guys. All right. Not to be too touchy, I saw some potential juror that said they were caring for a spouse that had cancer at home. Nobody? Is that the one that didn't show? Okay, good. Because I was looking for someone that said they jumped their hands. All right, and that's not the case. All right, last question, I promise. Who cannot be here? Let's see, today's Tuesday, Wednesday, quite possibly to the end of Thursday. I just saw your eyes. Oh, so that means you're gonna make me work Saturday, but because they're gonna let me out of this.
Yeah, this year I'm working 14-hour shifts, 7 days a week on nights, starting 6 p.m. every night.
6 p.m. when?
Since Friday. I'm working 14-hour shifts every night. I'm extremely sleep deprived. And I'll be able to, I'll try to stay awake.
Good job, man. Okay. My work like the judge,
Yeah,
you're a little bit.
I know that counted the excuse and exemption, but I had until 4 p.m. on Thursday, and they told me 10 a.m. on Friday.
Nice.
They're very considerate.
Yeah. Thanks for giving me 14s too, right?
Yeah, it's,
Why not 12s?
emergency, the plane crashed, and we're trying to get back.
Okay. My wife works 12s, so she'd rather work her 3 12s and be off for other for days a week.
I usually, my normal schedule is, 3-day weekends. I usually love it, but,
Oh, yes, they're right. 3-day week.
things go wrong. So,
All right, what about you?
No, I didn't work.
You can?
Okay. This is,
You got-
this is the least amount of work I've done all week. You gotta do me a favor.
Doing you a little bit of a thing. Okay. Anyone else say, man, this all the way to the end of Thursday, I just can't do it. I've got to go to the doctor, or whatever. Got a flight to catch.
I have a question.
Yes, sir.
How late does it go, in the evenings?
Well, see, that's up to that guy right there, the judge, Judge Holmes. I suspect that we go to close of business because we try to maximize the amount of time that the building is open. I doubt it'll be cut much shorter than that.
Like 5 o'clock?
Yeah.
Oh, okay.
Now, sometimes they get crazy, couple of doors down, and they go till late in the night and say, "I'll see you on Saturday," but I've never experienced that here. This setting, so I don't anticipate we're gonna have anything remotely like that. So we're good to the end of Thursday, all right? All right. I said that was the last question. Never believe a lawyer when they say last question. Here's the last question. Does anyone say, look, after hearing these two lawyers yammer on, I don't want to be here? Yes, that surprises me. I thought you would want to lead the charge and say, I'm in here, let's talk about nullification. You don't want to be here. Tell me why.
Because I'm a teacher and it's summer and I just want to do nothing. And I just need a break. I teach high schoolers. I just want that. I'm adjusting some anxiety meds right now and they are giving me insomnia. So I'm not very as I usually am.
All right, if there's an issue you'd like to talk to the court about regarding work, medication, any other factors surrounding that, kind of orbiting that, you're more than welcome to. Feel pretty confident. Hey, man, I'd rather, go to the beach tomorrow. It's not a good enough excuse. Hey, I appreciate you being honest. That's what we're here for. What do you say, boy, Howard, let's do? You're listening to him, aren't you? Tell the truth. All right. Thank you very much. Look forward to presenting this case. I anticipate we're gonna start testimony tomorrow, probably a little after lunch.
Okay, ladies and gentlemen, we're gonna ask that you step outside. We're going to probably call some of you back in for some additional follow-up questions. And you can leave the courtroom. You can go out either one of the two doors. So at this time, will everyone please stand? Panel leaves the courtroom. The proctors, Mr. Valdez. Y'all please stand. Be in recess.
you know.
Oh, have you seen it? Jefferson County Court at Law number 2 is back in session. Court is in session in 2 cases, cause numbers 24 CCCR 2011 and cause number 23 CCCR 0642. Both cases are styled in the state of Texas versus Alan Valdez. Now, ladies and gentlemen of the panel, when your name is called, we're going to ask that you have a seat in the jury box, and we will have our court coordinator, Ms. Glenda Segura, who will be calling the names.
Maria Carrillo. Mary Johnson. Roderick Tompkins. Denise Jihap. Lindy Goodwin.
Oh.
Alfred Lockridge.
So, okay. You can pin those badges on at this time. Okay, members of the jury, at this time, I need to administer to you the second of the 2 oaths. I need each and every one of you to raise your right hand. And after I finish administering the oath, please say, I do. Do each of you do solemnly swear or affirm that in the case of the state of Texas versus Alan Valdez, the defendant, you will a true verdict render according to the law and the evidence in this case, so help you God? Okay, you may put your hand down. Members of the jury, I will give you some general instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to a particular case. The facts comes from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the decision on the point of law. The reason for that, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate. Therefore, you can't be within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her, and the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in these cases. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deduction from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of this case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case or in these cases. Don't read any reports in the newspaper or watch television or even go on to social media and read reports about this case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. And make sure that you wear those badges at all times, because those badges that you have identifies you as a juror in this case. Ladies and gentlemen of the panel, first of all, on behalf of the citizens of Jefferson County and the staff here in County Court at Law Number 2, I would like to thank you for taking time out from your busy schedules to be here. Now, I know some of you probably think that, well, I came down here to serve on the jury and I wasted my time. Well, you did not waste your time. And the reason why you did not waste your time is because actually this case was on a docket on yesterday. And so we had several cases on our trial docket. And the reason why they were on the trial docket is because individuals have a right to have a trial by jury. Some individuals said that they would like to have a trial by jury. They were offered an opportunity to settle their case, and they did not settle their case. But on yesterday, some of those cases was actually disposed of. And the reason why they were disposed of is because sometimes individuals say they want a jury trial because they think one of two things are going to happen. Sometimes they think witnesses are not going to show up. And other times they may think the jury is not going to show up. But on days like today, when the jury shows up, it is not uncommon for individuals to have a change of heart. And what I mean by that is they say to themselves, you know what? After seeing the jury, you know what, that offer that the state made a few months ago, it looks pretty good right now. And so in essence, your presence helped us to move cases on our docket. And for that, we would like to thank you, because if you took time out from your busy schedules, and because you took time out from your busy schedules, we were able to administer justice and we were able to move cases. Now, I know that for some of you, that when you came to court today, when you came to court today and you had your paper that told you that you need to be in county court at law, or you might have had it on your phone. It told you that you had to be in county court at law number 2 for jury service. You looked over the top of the court, over the door outside the courtroom. You say, "Oh, this is county court at law number 2. This is Judge Holmes' court." Well, ladies and gentlemen, this is not my court. This courtroom is for the citizens of Jefferson County. In essence, it's your court. So anytime that you're in this area of county court at law number 2, you can have a seat in your courtroom. In fact, you can sit in an area that you're sitting in right now. We call it the peanut gallery, but it doesn't mean you can bring peanuts here and eat, because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and see what goes on in Jefferson County, and I'm sure you'll find that it's very interesting. Now, you'll have an opportunity to, once this case gets started, we'll start our testimony tomorrow at 1 o'clock. If you want to come back, you can sit in that area. If not, you can watch it on YouTube. Now, our bailiff have letters for you. She'll give each and every one of your letters. If you feel free, you can drop us a line. And before you leave, I usually give everyone a handshake. However, COVID is still in our community. There's a new variant that's out, but I can give everyone what I call an air handshake. So I would like to give each and every one of you an air handshake. Thank you for coming down here. And each and every one of you can have a blessed day. Our district clerk's office is closed at the moment. So if you need something from the district clerk, you'd have to come back on tomorrow. If you need something from us, we'll have our court reporter provided to you. So at this time, you are excused. Each and every one of you have a blessed day. Thanks for coming. You're welcome. Okay, ladies and gentlemen of the jury, this case will reconvene tomorrow at 1 p.m. So make sure that each and every one of you is back at 1 p.m. and you will have a seat outside the courtroom. You will remain out there until a bailiff come and get you. So at this time, you are excused. And again, you can take the badges home with you and make sure you bring them back and wear them every time that you come to court. Okay? So at this time, you're excused. Everyone, please stand as the jury exit the courtroom. Court will be in recess in this case until tomorrow at 1 p.m.
Thank you, Judge.
You're welcome. Oh, here it is. And this will conclude the calling of this case. This case will be in recess until 1 p.m. on tomorrow, June 4th. Everyone, please have a blessed day. It's County Court at Law number 2, Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. And attorneys, you are excused.